Hey, hello everybody, and thank you for joining us for this wonderful seminar today, Assessing Damages, Pain and Suffering. We're being presented here by the wonderful Sach Fernando, who's the principal of Maxiom Lawyers, and Tyen Redmond as well. We are privileged to have them present for us. Long-term client of ours and lovely people to deal with. Promises that this is going to be a really interesting seminar, and I urge you all to enjoy and share this afterwards with your team members. The recording will be sent to registered people within the day of this happening. And of course, the recording is also saved to our YouTube channel where you and your staff can watch it again at your leisure. May I ask if everyone please keep themselves on mute throughout the presentation so that noise from your home or workplace doesn't interrupt the recording. But at the end, there will be time to ask questions. If you have to leave before the end, please type your questions in the chat and I'll read them out. So without further ado, thank you so much, Sach. Over to you.
Thank you for that introduction, Michelle. It's really great to be here today to present to your team on assessing pain and suffering damages. I can see here joining us, there are some familiar faces, and there's some faces, some names that I don't recognise. I hope for those expert personal injury lawyers joining us, I may be repeating things you already know. I'd like this to be interactive as much as we can. So if you do have questions along the way, please feel free to ask. Assessing pain and suffering is a bit of a lottery. There's no formulas, as some of you are aware. There's no formulas to calculate the assessment of damages, and we turn to comparable cases for the injuries that our clients are dealing with. When we advise our clients that this is an appropriate settlement for pain and suffering. A bit about Tyen and I both work at Maxiom Injury Lawyers, and we both are accredited specialists in personal injury law. At Maxiom, as with many personal injury law firms, we operate on a no-win, no-fee basis. In today's presentation, we'll talk about the statutory maximums for pain and suffering, the considerations that a court looks at for pain and suffering damages, issues of contributory negligence, and we'll go through how some cases have recently been assessed in the jurisdictions of work cover, road accidents, public liability, and institutional abuse. And for the medical professionals that are joining us today, we will talk about the importance of medical report writing and how that works into the assessment of our clients' damages. Over to you, Tyen.
Thank you, and good afternoon, everybody. So just so everyone has an understanding, in Victoria, for the kind of primary personal injury claims, there are statutory minimums and maximums in most claims as to what general or pain and suffering damages can be awarded. So this table here sets out the current figures. They are tied to inflation, so they have jumped quite a bit in recent years, given the economic climate. But you'll see that there's a reference to both the Workplace Injury Rehabilitation and Compensation Act and the Accident Compensation Act. They're the two pieces of legislation that govern the Victorian Workers' Compensation Scheme. They apply depending on the date of injury with respect to a common law damages claim. And the transport accident one relates to the TAC scheme. What happens in circumstances where a judge or jury awards damages below these minimum amounts is the injured plaintiff actually receives nothing for pain and suffering. Likewise, if it's over the statutory maximum, the injured plaintiff would have their amount reduced to the maximum amount identified at that particular time. And you'll see down the bottom as well, currently the claims under the Wrongs Act, which are typically public liability and medical negligence claims, they are now tied to the statutory maximum provided under the work cover legislation.
So there's a number of considerations when assessing pain and suffering damages. And the first dot point you see there is age. The age of the injured individual is relevant because the younger they are, the longer they will suffer, arguably. Any pre-existing injuries or post-event injuries or injuries that fall outside the scope of the claim is relevant, because the injured individual is entitled to damages only for their compensable injury. We put in there external features, including drug addiction, alcoholism, that impact on their credibility. Their social, domestic, and recreational pursuits are relevant. At the end of the day, the law awards damages for the consequences of the injury to the individuals. We may all have a similar injury, but our lives are all very different. And so the law factors in how the individual's life has been adversely impacted as a result of the compensable injury. Treatment and the management required to treat the injuries are also quite relevant. Often we see someone with someone who's undergone an operation may be awarded higher damages than someone who hasn't been operated. So we'll get to assessments in a moment, but someone with an operated back may reasonably expect damages in the magnitude of between 250, 300, perhaps even a bit more, whereas someone with an unoperated back may be awarded damages in the magnitude of between 150 to 200,000. I emphasise that the courts look at the impact of the injury on the individual, but equally, these considerations play a large role in the assessment of pain and suffering damages. The last dot point there is contributory negligence, and I'll invite Ty to elaborate on that.
Thanks, Sach. So contributory negligence is a defence that's pleaded by the defendant, simply put to argue that the plaintiff's conduct or behaviour played a role with respect to the harm suffered, and therefore a discount or mitigation as to the amount of damages that should be awarded should be factored in. Usually what the court does is assess the pain and suffering damages, and then upon reaching that conclusion, calculates a discount for that contribution. This is something where the defendant has an onus to establish the elements of contributory negligence, and that is that the plaintiff failed to take reasonable care for their own safety, and that this failure caused or contributed to the harm suffered. Now, there are exceptions or different scenarios where this is applied in different ways. Understandably, if there is a sudden emergency or imminent danger, the expectation of what a reasonable person would do in those circumstances does vary. Likewise, you see these cases often arise in transport accidents around drink driving and intoxication, and often it turns on the knowledge of the passenger who takes a lift in the vehicle with the intoxicated person. What knowledge did they have at the time of accepting that ride? The standard and the expectations do vary depending on several factors. There's clear judicial decisions relating to how these are to be assessed for children and people with disability. In those circumstances, for a child, the question is assessed based on the standard of a reasonable child of the same age. Likewise, with somebody with a disability, it's based on a reasonable person with the plaintiff's degree of disability. In terms of typical reductions that we see, it does vary on the individual facts of the case. Probably one of the more common ones we see is a passenger or a driver in a vehicle not wearing a seatbelt. Surprisingly, that's far too common still in this day and age. Often in those cases, you would see somewhere around a 25% discount. Likewise, for people that are injured on motorcycles without wearing helmets. In a lot of cases, you probably would expect, if there is an argument for contributory negligence, the discount often falls between that 10 to 20% range, depending on the individual factual scenarios.
Thanks, Ty. So let's dive into it. The next few slides, you'll see a lot of case names. We won't discuss every single case, and we will circulate these slides with you all. But I will start with work injuries. The first case you see is the matter of Kozarov. Those in the jurisdiction are all too familiar with this High Court. This is a Supreme Court decision that where the assessment was made, but the matter went all the way to the High Court and has set precedent. But this matter involved a lawyer who suffered psychiatric injuries whilst working in the prosecution's unit for people with sexual offences. Her psychiatric injury was diagnosed as PTSD, post-traumatic stress disorder. She suffered symptoms of anxiety, nervousness, fluctuation of weight, flashbacks, overwhelmed with issues of concentration and muscle spasms. And the court awarded her $200,000 in pain and suffering damages. The matter of Tomasevich and the state of Victoria involved a 68-year-old injured worker who suffered from psychiatric injuries. The plaintiff was a PE teacher who was subjected to unfound charges of sexual harassment. The plaintiff suffered from chronic major depressive disorder with associated stress, anxiety, and panic attacks, and had regular treatment, high doses of antidepressant medication, inpatient admissions at psychiatric facilities, and a bad prognosis for recovery. The plaintiff in that case was awarded $425,000 in pain and suffering damages. Rierson was a shearing case where the plaintiff had suffered from a serious back injury, which was operated. They had some pre-existing back problems, but they never stopped working. They were quite restricted, and they were a candidate for further back surgery. In that case, damages were awarded in the sum of $250,000. The other matter I wanted to touch on was Di Pietro. Di Pietro involved a 53-year-old worker who was trimming a hedge and slipped on a rock and fell, sustaining a serious lower back injury that required surgery in the form of a laminectomy at the L5, S2 levels. They were left with severe lower back pain, left-sided sciatica, was taking Lyrica, tramadol, painkillers, a very stoic individual who was living with pain. They returned to work and retained some function, and was awarded $185,000 in pain and suffering damages.
In terms of some of the other cases there, McGiffin and Fosterville Goldmine is quite an interesting one, I think, for both the legal profession and the medical profession. The plaintiff worked as a nipper in a gold mine near Bendigo, and near the end of his shift in March, the 2nd of March 2018, he was hit to the head and right shoulder by a large rotating bolt attached to a boom on what was called the jumbo machine. He was taken to the Bendigo hospital. Afterwards, he returned to work about a week after this incident, having seen his GP and a physio. He worked for a short period of time before reducing to alternative duties, and then ultimately by the end of May 2018, he ceased work. As at the hearing of this matter in December 2021, he had not returned to work, so he'd been off work for 2.5 years at that point. Negligence had been admitted in this case, so it was purely an assessment of damages before the court, and the question of whether there was any contributory negligence, and if so, what reductions should be made. Ultimately, the court found that there was no contribution by the plaintiff. The injury, the primary injury that was suffered by Mr. McGiffin was complex regional pain syndrome type 1. He also had an adjustment disorder with mixed anxiety and depressive features. He had a right shoulder injury, which was surgically repaired by way of an arthroscopic decompression, vasectomy, and biceps tenodesis. And he later required further cortisone injections and hydrodilation. The consequences of these injuries were quite significant, and this is reflected ultimately in the award of damages. His right hand was in a fixed claw grip. He was unable to move his right arm. He couldn't use a knife and fork with his right hand. He required assistance with dressing, showering, and toileting. He was unable to lift his 18-month-old son. He was only 25 years old at the date of injury and 29 years old at the date of the trial. He was awarded $475,000 for his complex regional pain syndrome, which is quite a considerable increase on past cases. I'll also talk about the case of Alicia and Vision Australia. This is a psychological injury case. It was a 17-day trial, which all the plaintiff lawyers sitting in the room would feel for the lawyers that had to run a hearing that goes for 17 days, and it went over a matter of months. It was broken up into several sittings. This was a complex case that was found in favour of the plaintiff. The injury related to the grossly unfair treatment in taking steps to terminate the worker's employment, resulting in him suffering a permanent psychological injury. So it's quite an unusual case. The plaintiff successfully argued that the employer breached the contractual promises owed to him, as a consequence of which his employment was terminated, and he suffered principally very serious and ongoing psychiatric injury. Whilst he had some pre-existing anxiety, the court was very critical of the conduct of the employer in this case. He was diagnosed with major depressive disorder and adjustment disorder with mixed anxiety and depressed mood. He was unable to work. He was undergoing significant treatment, including ECT. He was young of age and severely affected. Now, the court made a couple of comments in this case which stand out quite strongly. The court said that the plaintiff presented as gravely psychiatrically affected by the circumstances leading to his termination. His voice was flat and he regularly looked at the floor. Eye contact was irregular. The cross-examination took little or no account of that presentation and proceeded on the evidently assumed basis the plaintiff was in a position to give evidence as if he were perfectly psychiatrically fit and well. The court also said that it will be evident that the plaintiff was treated appallingly by the defendant and consequently suffered very serious psychiatric injury. He was young and tertiary educated when it occurred, and he most likely now faces a lifetime of psychiatric intrusion and disability. And the plaintiff was awarded $400,000 for general damages in that particular case. I'll also speak to the matter of Cooper and Citywide Services Solutions. This is another terribly sad case. The plaintiff had previously been an exceptional endurance athlete, having previously competed professionally in cycling, ultramarathon, and Ironman events. At the time of the injury, the plaintiff was the operator of a street sweeper through a labour hire group. The plaintiff had parked this vehicle near a 7-Eleven store and had entered the store to make some purchases. Whilst in the store, the plaintiff saw that the sweeper was moving. She ran out to the vehicle and it was ultimately crushed between the vehicle and a wall, suffering extensive injuries. The plaintiff argued that the host employer, so not the labour hire company, but the company responsible for the vehicle, was negligent as it failed to train and instruct her in respect to the operation of the handbrake of the sweeper, and it also failed to install an alarm system which would have alerted her as to whether or not the handbrake was engaged, and the court accepted that argument. Now, she has a laundry list of injuries. She had multiple pelvic fractures. She had 17 fractured ribs. She had T3 and 4 vertebrae fractures, multiple superior end plate fractures, countless other spinal fractures. She had suffered a mild traumatic brain injury. She had left-sided cranial nerve 5 palsy, and a whole host of other neurological conditions which affected her, as well as having a moderate adjustment disorder with depressed mood. Now, the defendant argued in this case that she had a capacity to work, but the court didn't accept that. The plaintiff was trying to cycle at home on a modified bike in a kind of simulated environment for her own mental health, but the court didn't think that was sufficient to suggest that she had any work capacity. At the time of trial, she was unable to work still. She had constant and chronic pain. She had extensive scarring. impacted sleep, reduced sexual functioning, loss of sensation below her waist, as well as in her breast and right leg. She had incontinence issues, suicidal ideation, and she'd lost that athletic capacity that had formed a large part of her identity. Now, these are catastrophic injuries by all meaning of that definition, and the court awarded her $550,000 damages for those injuries on a pain and suffering basis. The last one I'll speak to is the matter of Bell and Nexus Primary Health. This is another psychiatric injury case with pretty horrifying circumstances. The plaintiff was a family violence support worker in regional Victoria who had a not insignificant history of pre-existing mental health issues requiring at least one period of hospitalisation in the past. In the course of her employment, she learnt of other co-workers being violently attacked at work by members of the public that were frustrated with the organisation's involvement in their family affairs. In 2013, the plaintiff was attacked near her workplace, and the individual that attacked her not only injured her, but also made threats that he would kill her if she continued to be involved in his family affairs. The same assailant is assumed to have later sent the plaintiff to her home various threats and also thrown a brick through the window of a house. The offender was known to the employer as being high risk, and the offender had also previously made complaints about her to the employer, and the court accepted that the employer made no steps to move the plaintiff off the offender's family violence matter, exposing her to the risk of this escalation and ultimately the harm that was suffered. She was diagnosed with post-traumatic stress disorder. She was no longer able to work. She's reluctant to leave the house and is generally avoidant of all social occasions. And she was awarded $375,000 with respect to those damages. Sach, I'll pass over to you.
Thank you, Ty. We'll now look at some TAC cases. The first of those is Doomand Income, involving a 53-year-old who was involved in a road accident. Despite suffering from quite a chronic psychiatric condition, diagnosed as major depressive disorder, chronic pain disorder, which had required hospitalisation, there were also other external factors that impacted on the plaintiff's mental state, including her daughter running away and joining ISIS, which was argued by the TAC as a big consideration in the assessment of her psychiatric injuries. The plaintiff had undergone some serious psychiatric treatment in the form of transcranial magnetic treatment and electric convulsive treatment. Her consequences also included interference with memory, cognition, concentration, sleep, and she was also taking antidepressant medication as well as painkillers for her physical lower back injury. She was awarded $300,000 for her pain and suffering. Then we have Jordan Randall and Joseph Gelsey, which involved a pedestrian who was struck by a vehicle who suffered a right knee injury, right tibial plateau fracture, right ACL rupture, right lateral meniscus tear, chondral injury to the left patella, and femoral condyle. They also suffered from secondary psychological symptoms and was awarded $504,000. Biggs and O'Connor is a death claim where Mrs. Biggs, the partner of the deceased, brought a claim for her psychiatric injury. She suffered from anxiety, depression, and post-traumatic stress disorder due to the death of her husband. And she was awarded $275,000, although in that case, whilst negligence against the other driver was established, there was considerations of contributory negligence that played a role in the assessment or the reduction in Mrs. Biggs's awarded damages.
Kessler and West is a recent decision in the Supreme Court. The plaintiff, Alexandra, was a pedestrian crossing a road when she was struck by a car. The car was making a right-hand turn and failed to give way. The plaintiff was the daughter of Holocaust survivors, and later fled the USSR via Italy in 1989, coming to settle in Australia. She had several pre-existing health issues. The one which was the attention of the court was a pre-existing depression and anxiety. The significance of these pre-existing mental health issues was centered to the dispute before the court in assessing her damages. Negligence was admitted prior to the hearing of this case, so it was purely an assessment of damages and the extent to which these pre-existing health issues played a factor in relation to that. From the accident, she suffered a right lateral tibial plateau fracture and a fracture of the proximal head of the fibula on the right side, requiring surgery on her knee for an open reduction and internal fixation of the lateral tibial plateau fracture and a bone graft, as well as being diagnosed with post-traumatic stress disorder. The judge in this particular case makes some very succinct and clear summaries as to why he reaches the conclusions with the pain and suffering damages that he finds. I might just read them out quite quickly for you. They say that the medical and lay evidence that demonstrates that the plaintiff's physical and psychological injuries impact on every facet of the plaintiff's life. They accepted that the right knee injury causes the plaintiff ongoing pain and restriction. Her lifestyle is seriously affected. She previously had a strong social life, which is now extremely limited. The plaintiff was an active woman who enjoyed traveling and was involved in her community. The immediate months following the accident left her wheelchair-bound and dependent on others. Her treating doctors described an active woman who was very kind, optimistic, and very resilient before the accident. The accident has had a profound and enduring impact on the quality of the plaintiff's life. The plaintiff has, over her life, been able to overcome adversity and has largely dedicated herself to caring for others, including her elderly sick parents. She overcame breast cancer, and her psychological conditions were largely well managed. She faces the prospect of further surgery. On the evidence, her psychological state has little chance of any material improvement. The plaintiff will not be able to embark on a new career or full-time work due to her injuries and will be dependent on people for support in many aspects of her life. That summary there is a perfect tie back to the categories of what's considered in an assessment of damages that Sach spoke about earlier, and I think is a really good example of the court accepting a plaintiff as genuine and appreciating the significant consequences of an injury like this. Over to you, Sach.
Thank you, Ty. Public liability and medical negligence cases are next. The first is Mason and the City of Darebin, where a 56-year-old plaintiff had a slip and fall on a pavement. They slipped on cream located on the pavement after going to a bakery. They suffered a left shoulder injury. It was a rotator cuff injury that required operative intervention. Her consequences involved difficulties with various activities of daily living. They were medicated and suffered from, in addition to the physical injury, a psychological sequelae, and damages in the sum of $195,000 were awarded. We have Vlaming and von Marburg, which is the only medical negligence case that's listed in that list, involved a plaintiff who, as a result of failed surgery, suffered from facial nerve paralysis and right facial nerve and inner ear injuries. As a result of that, they also developed a psychiatric injuries in the form of post-traumatic stress disorder, adjustment disorder, and depression. The plaintiff was highly embarrassed by their appearance and needed to constantly lubricate their eyes. They suffered from loss of hearing and obvious physical and visual deformities. The plaintiff was awarded $280,000 for their pain and suffering. We also have Mitch and Ballon and District Soldiers Memorial Bush Nursing Hospital and Hospital, which involved a 55-year-old plaintiff who fell while walking across a landing or a digging next to a hospital premises. They suffered from a serious aggravation of a pre-existing left knee injury, which resulted in an arthroscopy. The consequences involved needing a TENS machine, reliance on painkillers, including endone, difficulties in squatting and kneeling, difficulties performing their activities of daily living and domestic chores, constant pain and swelling, and a subsequent requirement for knee replacement in the future. Damages were awarded in the sum of $110,000.
There's also this case of Ciaris, which I'm hoping I pronounced correctly, and SPI Management Proprietary Limited. It's a recent decision this year. It's an interesting case from several perspectives. Unfortunately, the plaintiff in this case suffered injury shortly after midnight on the 1st of January 2019. So she was at a New Year's Eve function at a particular venue in Preston. It was a festive atmosphere, and the plaintiff alleged that she was dancing on the dance floor when her feet became tangled in streamers on the dance floor, or alternatively, she slipped on streamers, causing her to fall. The detailed judgment is quite interesting because there's speculation as to what dance they were performing at the time, the pace of the dance, all these types of things, but there was no evidence of alcohol consumption. There was evidence that she was wearing 6-inch high heels at the time, and it was really a contest as to what was the cause or the exact mechanism of the fall and whether the occupier of that venue was responsible for that. This poor lady fell over and landed heavily on her left-hand side, and she suffered a fractured dislocation of the humeral tuberosity of the left shoulder, which was surgically repaired, as well as other soft tissue injuries to her left lower limb. As a consequence of that, she was unable to lift, or was still unable to lift, her left arm overhead. She reports ongoing pain and discomfort. She requires medication to obtain comfort in order to sleep. It impacts her ability to undertake things like cooking and cleaning around the house. She's not unable to lift heavy groceries. She's restricted in terms of brushing her hair and getting dressed, and unable to tend to her garden, and has difficulty in terms of interacting with her grandchildren. Now, the court ultimately assessed her damages at $150,000. She had some pre-existing left shoulder issues, which some time prior had surgical intervention, but had made a full recovery. However, it is important to note in this case that the court did not accept that the venue was responsible for this and found in the favour of the defendant, despite making a determination as to what damages would be assessed in relation to these particular injuries.
Thank you, Ty. We then have institutional abuse cases and horrible circumstances in both cases. In the matter of Wax and Caprese and others, this case involved a plaintiff who suffered from chronic post-traumatic stress disorder, adjustment disorder with depressed mood, and substance abuse dependency. Consequences included reckless behaviour during the plaintiff's teenage years, and that continued on to adulthood. And the plaintiff was awarded $200,000 in damages. We then have Perez and Reynolds, and again, an abuse survivor who suffered from ongoing from a psychiatric injury, and their ongoing psychiatric symptoms included anger, frustration, guilt, intrusive thoughts, distrust of people, alcohol dependence, suicidal ideations. They developed a stutter, and general damages were awarded in the sum of $265,000. The final slide involves medical report writing, and we included that because there are a number of medical professionals that are joining us today. Typically, us lawyers will request reports from you ahead of a hearing or for perhaps an impairment claim. And the purpose of those reports is to get an understanding as to what our client's condition is and its effects on their lives. The questions that are asked are typically those that are in front of you about the history you've obtained in relation to the circumstances of injury. Are there any pre-existing injuries? What's your diagnosis of our client's injury? What's caused it? You'll see in quotation marks a reference on the balance of probabilities, and that's the standard of proof. Your opinion regarding the cause of injuries, it needs to be that on the balance of probabilities, either that that employment was a significant contributing factor to the claimed injuries, or that the transport accident was a cause of their injuries. When it comes to the assessment of pain and suffering damages, what you have to say with respect to the impact of the injuries on our clients' activities of daily living is very important, because those reports that you write are used to substantiate what our clients themselves have to say are the consequences of their injuries. So typically, in a hearing, we would have had our client swear an affidavit that where they depose to the consequences of the injury on their lives. So they talk about how life was before injury and how life has adversely been impacted, the impact on their sleep, mobility, function, intimacy, social interactions, how it impacts on their recreational pursuits, so that we can convince a judge that the injury has resulted in serious adverse consequences. But what they say alone is not going to win their cases. What will win their cases is if the doctors that treat them also detail in their medical reports how the injuries impacted their lives. And often we would ask the doctors to consider the pain and suffering consequences that are detailed in the affidavits, and to make any comments. And typically what we find is that doctors, if they're provided the affidavit, will read it and at least make a comment as to whether they agree that the limitations that have been deposed to are correct and are in line with injuries of the nature that the plaintiff is suffering from. So for the doctors in the room, in this virtual room, the more detail that you can provide in your reports, the better. Referencing the client's symptoms is very important, and your prognosis with respect to their recovery is also very important. That's really all Ty and I hope to cover today. Can I open it up for any questions that anyone might have?
Thank you so much, Sach and Ty. That was really very, very interesting and very, very informative. People, if you have a question that you would like to ask, if you can unmute yourself and pose your question directly, or you can type your question into the chat. Okay. Isaac, you have a question?
Question. I'm very happy with the presentation. It was excellent. Thank you.
Thank you very much. Look, if anyone does have any questions, our details are in the slides. Feel free to reach out anytime. This is an interesting topic for all of us. And it never ceases to surprise me how courts assess damages, and you can have a wealth of experience in this jurisdiction, but a jury will always surprise you. I still remember the first jury trial that I ran, which involved a 69-year-old with an unoperated back. And there were issues as to causation because of the plaintiff's age, and also an absence of reporting throughout the course of his employment. And he worked at a timber sawmill where he was handling timber sleepers repetitively, and over a period of about 18 months developed back pain and lodged a work cover claim, which was ultimately accepted. But the argument from the Victorian Work Cover Authority was that this injury was not caused whilst with this employer. And the basis of that argument was that there was no report of injury during the course of this particular employment. And we have a gentleman who is in their late 60s with a bad back. And so they were not prepared to make any offers in the running of this trial. And mind you, we were aware of the risks associated in the trial, and we were all quite nervous about how a court would respond to this case. And so when attempting to negotiate even from the statutory counteroffer was positioned at a very, very modest amount, and it was from memory, it was around 60,000. And ultimately, we went before a jury, and it was a 3-day trial. Thankfully, unlike the case Ty mentioned, it was definitely nowhere near the 17-day trial. But after 3 days, the jury awarded this gentleman $350,000. 69-year-old unoperated back with serious issues when it came to proving causation, but ultimately the jury took a very common sense approach. And also the credibility of our client was of utmost importance. He was such a genuine, good, hardworking Australian man who was very stoic and resilient. And often we have concerns when our clients are very stoic and resilient because they don't complain. And part of the assessment is, well, what are their consequences? So if they're not complaining and they're not talking to doctors about their pain, how can even the doctors support the fact that the injury is having ongoing consequences? But I say that, I mentioned that case to illustrate how surprising jury verdicts are.
Absolutely. Thank you so much, Ty and Sach, for making time for us today, for putting together this terrific presentation. Thank you, everybody, for joining us today. It was just awesome. Thank you so much.
Thank you, Michelle.
Have a great rest of the day, everybody.
You too. Bye-bye.